1, 2, 3, come on.
Welcome back, ladies and gentlemen. This is Law 254. We seek to demystify the law, give you useful tips and guidance on how you can interact with it on a day-to-day basis, basically putting the law in your hands. As you're aware, we're in the middle of one of the worst crises, the coronavirus, which has caused a lot of disruptions, contractual disruptions. And today we want to talk specifically about the relationship between landlords and tenants. The fundamental question that we seek to answer today is, do landlords have a moral and or a legal obligation to reduce rent to tenants? Do they have a moral or a legal obligation to reduce rent to tenants? Before we dwell into that, we first want to understand the primary document that governs the relationship as between the landlord and the tenant, and that's the tenancy agreement. So you might want to retrieve your tenancy agreement from wherever it is and peruse it one more time just to check a few clauses therein that could help you enforce your rights. So the first question was, does the landlord have a moral obligation? And the answer is a resounding yes. Absolutely yes. The landlord has a moral obligation. But does the landlord have a legal obligation, which I think is the most important question for us to address today? And the answer is it depends. In the default, the landlord does not have an outright legal obligation outside what is provided for in the tenancy agreement or outside any government pronouncements. So if it's not provided expressly in the tenancy agreement, or if the government doesn't intervene to give a pronouncement, then by default the landlord might not have an outright legal obligation to give concessions in the form of rent rebates or waivers to the tenants. So if you seek to rely on the tenancy agreement, then it must have provided expressly for events, the occurrence of events for which you can rely to avoid the contract, and that is provided under the first majeure clause. So normally, as between contracting parties, there's always a need to address external factors that are unforeseeable. Like in the event that this happens, that hadn't been foreseen by either of us, then we can avoid the contract. So in that particular provision, it would have provided for pandemics, wars, terrorist attacks. So if any of this occurs, then you can avoid the contract. So how do you invoke the first majeure clause? First, you need to prove that the event happened, but it's just not enough to prove that it happened. You need to prove that as a result of it happening, you are unable or utterly incapable of fulfilling your contractual obligations. And third, you must prove that you couldn't have mitigated the occurrence of the event and or its effects. So if you prove this, then you can comfortably avoid the contract, or you can get into negotiations on rent holidays or waivers or rebates from your landlord. Okay. Now the second thing, so you can ask as a tenant, I do not have a tenancy agreement, number one, or two, I do have a tenancy agreement, but it does not provide for these circumstances. It does not have a force majeure clause. What should I do? So number one, and I think it's good news, the government made a pronouncement that this pandemic should suffices to be a force majeure event to all impending or outstanding contracts. So you can rely on that government pronouncements to invoke your rights. But secondly, there's also a doctrine of frustration of contracts. So the doctrine of frustration of contract would largely apply to commercial leases, commercial tenants, because it's as a result of you renting that place that you're making money. So if you're not making money because of COVID, something that is out of your control, then you can invoke that doctrine that that the contract has been frustrated, and thus you avoid paying rent, or you get into negotiations with your landlord to reduce the rent through rebates or rent holidays, etc., etc. So those are some of the legal recourses that you can have as a tenant to pursue your rights during this pandemic. However, there is also now the other side of things. As I said, it's not an automatic guarantee that because COVID happened, that then you can invoke the first majeure clause. It needs to be proved, and sometimes the threshold is very high in terms of how you're proving the whole thing. So you might also want to approach it in a more diplomatic way, and that is simply just putting a persuasive case to your landlord as to why they should give you the concessions. So you might want to write a very elaborate letter, or your lawyer can help you with this. Write a very elaborate letter stating that you've been a tenant there, you've been a good tenant in the past, and your particular circumstances. There's a legal doctrine that goes, equity always aids the vigilant. And even there's an English saying that says the squeaky wheel always gets the oil. So it's up to you to put a persuasive case to your employer, or use your lawyer to put a persuasive case to your employer through a letter, so that the employer can consider reducing for you your rent. It helps if you've been a good tenant. It helps if you've been paying rent and you've not been defaulting in your rent payment. It helps if you've been cooperative in the past. It helps if there are no complaints from other neighbors. If you're a good tenant generally, then the landlord should be inclined to extend some concessions to you. As I said earlier, the landlord has a moral obligation to do this, because during good times you remit your rent, and during bad times he should be human enough to also consider. I hope we've been helpful. I'll be happy to help in case you need any legal letter to that effect. But basically, those are the basics. You can just put together a letter yourself explaining those things, and you'll be just fine. Keep safe, subscribe to our channel, and we'll be giving you useful tips during this time. We'll be covering contracts and how contracts should be handled during this time. We'll be covering insurance, we'll be covering employment matters, which is a big thing right now, and even post-COVID. And so keep it locked here, and we'll be happy to share the useful legal tips. Thank you.